I hit him, I hit him, I hit him, I hit him.
Karen Reed is innocent.
We find ourselves deeply divided by fundamental differences in our opinions and state of mind.
We stand for the O'Keefe family. We stand for John O'Keefe. This is an abomination what's happening.
No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
We're in Dedham, Massachusetts this morning as jury selection continues in the retrial of defendant Karen Reed. She's accused of killing her boyfriend, Boston police officer John O'Keefe, by knocking him over with her car while she was driving drunk. This was in January of 2022. And as of this morning, there are 16 jurors out of 18 that have been selected. And we've seen jurors dropping as days have gone on. So who knows what this morning will bring. Opening statements could potentially happen tomorrow if they get the jury seated. Court TV crime and justice correspondent Matt Johnson has the latest.
Julie, good morning. Today is day 10 of jury selection in the Karen Reed murder retrial. Monday ended with no additional jurors being seated to hear the case. So far, 16 jurors have been seated. That includes 8 men and 8 women. The court is looking to seat at least 18 before opening statements. There was also a number of new court filings on Monday, including journalist Gretchen Voss from Boston Magazine and the blogger known as Turtle Boy. Both filed motions to be excluded from sequestration because they want to be able to cover the trial even though they're on the witness list. The Commonwealth also filed notice that prosecutors intend to use interviews that Karen Reed has given leading up to the retrial.
Mr. Reed, you mentioned that this case is national now.
Yes.
Today, prosecutors filed a notice that they plan to use your daughter's statements as evidence against her and your interviews as well. How does that make you feel?
Come at me. I live by the truth. I answer to a higher maker. And I'll tell the entire truth. And there's nothing we are hiding in the Reed family.
And again, jury selection continues today, which means opening statements could be as early as tomorrow. Julie?
All right, so let's talk about this case some more. I want to welcome in a very special guest. He used to head up the homicide unit in Norfolk County, Massachusetts. Attorney Rick Grundy in the private sector now and joining us this morning to discuss the case. Rick, always great to have you here. Could we talk a little bit about what the state is going to have to be proving here? And I'm seeing so much confusion among folks when I see things come up done by content creators on TikTok or wherever, where people are going, how could this be a murder? How can you have a murder? There was no planning. There was no, and they're getting at the lack of premeditation. And I want to say, well, look at the charges. This isn't murder 1. This is murder 2 we've got. What does that involve in Massachusetts, Rick, to get to murder 2? What kind of intent needs to be proved?
Well, that's a great question because murder 2 in Massachusetts has been described at times by a judge to a jury as murder that is not murder in the first degree. There's a number of ways in which murder can be a first degree murder, but in this case, and usually it is by way of premeditation, which does not, I think the looking at it from the back end, it's that second degree murder does not have to have premeditation in the sense of the first degree homicide. So there's a blurred line at best between a really bad voluntary manslaughter case where it's just a super high degree of negligence to prove guilt, and a second degree in Massachusetts, which takes it to just another level where there's something more than negligence. So it's not described as a specific intent, but with some level of intent or depravity be above the normal standard of negligence. And it's a gray area. There's no question about it.
Sure. Rick, would recklessness get the Commonwealth there?
Again, so we're right with the foot on either side of the line at recklessness. And to be honest with you, which is not, when it comes to jury instructions in the law, not how you want to have it play out. But it's going to depend on both the evidence and the sufficiency of the arguments on either side with respect to, is that recklessness at a level where there's a depravity for human life in the action, or is it more along the lines of negligence, just unintentional, completely negligence in their actions?
Well, this is fascinating, Rick. Does this hinge on whether she was allegedly trying to hit him, or whether she was just not thinking, enraged, and did a three-point turn and happened to hit him? Is that kind of the line it teeters on?
So for second degree, arguably, and I think a lot of times this is the way it's charged this way. If she puts it in reverse and says, I'm going to hit this guy, you could go with premeditation there. You're going to hit a person with a car. There's a likelihood that they are going to die. But I think in this situation, they're like, we don't have strong evidence. They're having an argument. She's under the influence of alcohol, that there was, and as you know, Julie, premeditation can occur within seconds. But they decided that the evidence there was not strong enough to establish that, and that's what landed them on second. You got that depravity for the well-being or life of another by purposely putting it in reverse, going backwards, seemingly with the intent to hit this person. So that's kind of what put them in the middle ground. And I hate to say it, but I've certainly seen situations where a prosecutor's office will charge second degree looking for a plea on manslaughter.
Sure. Rick, you know, I've said all along that I saw this case as a manslaughter case. I've said it before, I'll say it again. I wonder if we would be here today had the charges not been upped. When there was a decision made to go to the grand jury, I can see why they've gone with murder too. I get it. Yes, I acknowledge it's legally substantiated, but on the facts, I can also see this being a manslaughter case and being resolved with a plea. Do you think had the charges not been upped, then this potentially would have been resolved that way?
I think that's an absolute possibility, and there's so many contingencies to this case. If we go back to the very start, and Court TV was there at the very early onset when she was arraigned in the Superior Court, when Dave Yannetti was the sole attorney on it. And the main focus was this broken tail light and the injuries on the arm of Officer O'Keefe. At that point in time, you know, and again, the history of this and how much you bring before a jury is a question, but the history of this is that there was an individual who goes by the name of Turtle Boy, who is behind a keyboard until recently, saying whatever he felt he wanted to say, not answerable to anybody. And that is where this defense, this third-party culprit defense, the seeds of that were sowed and hoed and grown to a certain extent by Turtle Boy, and then taken on by the Reed defense. So take those things out, put this in district court as a vehicular homicide, and I could very well see it going by way of a plea. And I can tell you that I've had conversations with people as intimate to the case as can be on the defense side that initially thought that that was a path it would go.
Rick, I appreciate your honesty. Thank you for all of that. Let's talk about something that's going to be coming into the trial. We've discussed it on Court TV. Now it's official, let's say, a recent filing by the Commonwealth providing the notice to the defense that they intend to use Karen Reed's statements, which they can, as you know, according to the rules of evidence. For anybody wondering, a defendant's statements can come right in. It's excluded from the hearsay rules. I want to play for you, Rick, a couple clips that I think might be hard for the defense to reconcile. Number one, this is Karen Reed and her team when they called for a press conference early on. This is before there was national attention on the case, before anybody really knew much about it, and they were screaming, cover up, cover up. Let's take a look.
It feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. Just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
Okay, so let's contrast that with her sit-down interview with Boston 25 reporter Ted Daniel. Here's what she said when asked who did it.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Rick, these statements, how do you think the defense is going to reconcile them?
Well, I think they're not. And quite frankly, they don't necessarily have to in front of this jury, because I think in their reflection, as far as a retrial is concerned, what they need to do is take a step back from this. She was framed. She is innocent. Because I think they probably realize at this point in time that they took on a burden there that they do not have to take on. And I think if I were a defense attorney, one of the most telltale statements I heard post-verdict was a juror who went live and said, at the end of this case, I just didn't know what happened. The fact of the matter is that translates to not guilty. Commonwealth's burden 100% to prove this. You don't know at the end of the case what happened. That person is entitled to a verdict that reflects that and not guilty. But they missed out on that because the jury went in there with two stories, a stronger presentation from the defense, and felt that they had to decide on one of those. So I think what they want to do now is take several steps back. To the extent they have to explain the courthouse step interview, this was Karen in her defense, not an attorney, not saying we know who did it in the sense of that we have the individual, but we know what unfolded and it just wasn't her. And beyond that, just the prosecution, and their burden.
Rick, appreciate you sharing that. I am not surprised in the least. One of the things, as you know, I teach trial advocacy, on the side, when I have time. And one of the key things is you teach law students and lawyers, you develop your legal theory, essentially, why you should win, why your position is right. And to your point, it was not clear. The Commonwealth didn't do a great job at explaining the exact story of what happened. And then you have the defense trying to put forth, their story, and they exuded a lot of confidence, fell short when it came to the evidence in proving it. As we know, the judge never did give them that third-party culprit instruction that they sought. But this time, it's got to be different, and I really think it will be different. We have someone who teaches trial advocacy, one of the best lawyers around, Hank Brennan, now driving the train for the Commonwealth. Rick, let me ask you, please, a little bit about the jury selection process going on. Do you think we're going to get there anytime soon? I'm curious if you think that we're going to see this jury seated this week, or if it may even take a little longer in light of the fact that these jurors keep being seated and then keep dropping like flies.
I'll only say that I think from the first trial and perhaps carrying on here, this court has been a gracious with respect to time, not pushing parties as hard as I usually see in a case of this nature. Yes, I think we'll sit a jury this week. I think if you have to, instead of bringing 50 in, you bring 100 in for the next couple of days, but you get the job done, because as we see, the longer this goes on, you got to be hoping you're not losing more than you're getting.
Mm-hmm. Right. We'll see if today's the day. Maybe it'll be the day they hit that magic number 18 and keep it. Rick Grundy, I know we have to let you get off to court. You're a busy guy. We certainly appreciate you taking us to school on what's going to happen in terms of the proof process the Commonwealth has to put forth. Thank you so much. We'll see you soon.